Good morning, everyone. Thanks for joining us this morning. This is our second session in the webinar, NRE Webinar Week, Natural Resource Enterprises Program here at Mississippi State University Extension Service. I'm Daryl Jones, a wildlife professor with Mississippi Extension Service and Mississippi State University and Department of Wildlife Fisheries and Aquaculture. I've got a very dear friend with me this morning. He's a brother to me, Mike Massey. He is the lead principal partner attorney in Massey, Higginbotham Vice in Flowood, Mississippi. Mike has probably done 150 of these webinars. I mean, literally over the years. We got to know each other since 2005, and the NRE program has done multiple events in Mississippi. Mike has talked at every one of those. He does a lot. He'll tell you about himself, but he has an accounting degree, a CPA. He went to Mississippi State for his accounting degree and then Ole Miss Law School and started his law firm business in Jackson and Flowood. He specializes in lots of things, particularly in contract law, which with NRE and having hunting leases and starting recreational businesses on your property, one of the biggest trip lines I think we see in talking to landowners, Mike, they're worried about legal issues. And so Mike provides tremendous, straightforward information to you about those kind of issues and what we can do to limit that liability exposure and just good common sense things to minimize hazards on your property. So we're going to talk about that this morning. And without further ado, I'll let Mike talk about himself a little bit and then and enlighten us about legal issues and with our land ownership, Mike.
All right. Well, thank you, Daryl. Daryl makes a good point, and I'm sure he's going to make y'all all fill out these evaluations before you get done here. He likes to collect all that information, being the PhD that he is and all that kind of thing. But what we've learned through the years is all these outdoor recreational ventures sound great and people are excited about it and think it's got some potential. But we know that the number one thing that will possibly stop you in your tracks is potentially a fear of liability. What if somebody gets hurt on my property? And so I'm here to try to give you some ideas about what your obligations are as landowners and folks that are on the land, and tell you a little bit about Mississippi law and maybe calm you down about some of those type things. And so that whether you're just a landowner that's bringing out a Sunday school group or are really looking to do something bigger, and there's so many things people are doing these days on the property. I mean, it has blown up since we've been doing this, has it not? I mean, a couple of things that have happened, by the way, along the way is like they passed this agritourism statute in Mississippi to try to give landowners a little more comfort, about, not necessarily feeling like they got a lot of liability every time somebody trips over a stump hole. So you can actually, get qualified now as an agritourism professional, through the Mississippi Department of Agriculture, and fill out some forms and do some things, and if you'll post signs on your property that say a certain thing, like for instance, it's got to say something like that under Mississippi law, there is no liability for an injury to or death of a participant in an agritourism activity conducted at this location if the injury or death results from the inherent risks of the agritourism activity. Inherent risks of agritourism include risk of injury inherent to land, equipment, and animals, as well as the potential for you or another participant to act in a negligent manner that may contribute to your injury or death. You are assuming the risk of participating in this agritourism activity. That's something that's got to be posted like word for word. There's a statute on this, but I thought I'd just tell you that a little bit, because we'll get into that in a whole lot more detail. But the point is that a lot of people are going to be worried that if people are on their property and they get hurt, that they're going to be liable for that. So let me tell you a little bit about that. So in analyzing that issue, the first thing you ask is, in Mississippi, in terms of the liability of a landowner, you look at what is the status of the person who is on the property. And basically that's one of three things. That person could be a trespasser to whom you really don't owe any duty. You don't have to keep a trespasser safe. You don't have to make sure your property is safe to traverse and all that sort of stuff.
I can't shoot a trespasser.
That's the one thing you can't do is intentionally or willfully, that's these legal terms, willfully or intentionally injure a trespasser, but you don't have a duty to have your premises safe for that trespasser because they're not supposed to be there in the first place. The intermediate category is what you call a licensee. Now, a licensee is somebody who has permission to be on your property, but you're not benefiting necessarily from them being there. You might have, the Sunday school group might ask if they could come out to your farm and have a church picnic on a Sunday afternoon. You don't have much greater duty to a licensee who has permission to be on your property than you do to a trespasser. With this exception is that you can't, your active negligence can't be the reason that this person has gotten injured. And the best example I could give you of that is, if you had a group of Cub Scouts out spending the night or something at your farm, and you decided to do a little hayride for them, and then you decided to gun it when you hit that hill, and let's give them a real thrill and bounce them, and you bounce a few Cub Scouts off the tractor or something like that, then you're going to have a problem. But you're actively being negligent. They didn't get injured just by being on their property. Really, you injured them in that circumstance. So you got trespassers, you got you got almost no duty other than not to intentionally hurt that person. You got a licensee who has permission to be on your property, but you're not really financially benefiting in any manner. And at the far end, you've got what's called a business invitee. And if somebody is an invitee, and to this person, we're talking about you are benefiting from them being on your property. They're paying you to be on your property. They might be paying for a paid hunt or to come to your pumpkin patch or your Christmas tree farm, but you're inviting them there. You're benefiting from them being on your property, and to that person, you have a duty to either make your premises reasonably safe or to warn them of a danger which is not apparent to them. You don't have to warn people of obvious dangers, but you're supposed to warn them of something that may not be apparent, that the bridge is about to collapse. You might better have like don't cross the bridge. These old four-wheeler bridges. I'm thinking about growing up hunting at the deer camp I did, and my goodness, we'd be making. We'd take a chainsaw and drop trees across a creek and try to drive across it with four-wheelers. That's just the way we came up. That may not be the best idea if you're charging people, to be on your property hunting. And by the way, y'all see this all the time. When you go to a grocery store and you're walking down the produce aisle and you see those little yellow triangular signs that are sitting up there and they're saying caution, wet floor, things of that nature, they are doing their best to minimize their liability by telling you that you could potentially slip here. In fact, in my opinion, everywhere I go now, I don't know if I can get into a grocery store anymore without produce having some of those things up there. It's almost like they're doing them even when there's not a slippery floor, just to set up, the defense that, that we warned somebody, because usually if somebody gets hurt on a slip and fall, it's happened before somebody can do something about it. If they knew about it, they'd get over there promptly and fix it up. So, but you're a business invitee because you're there to make a grocery store money. So they're warning you of a danger. Well, so that's the same thing with land. So you either got trespassers, licensees, or invitees. And by the way, just before we get going here, this is usually a talk that I'm giving live to people. We get a lot of questions, and you're going to notice on your Zoom screen, you're going to have a button where if you want to, you can type a question in, and we'll be happy to field as many of those as we can. So don't hesitate to, if I say something and you want got a little question about, go ahead and fire them off, and we'll try to answer those as many as we can. So back to the fundamental premises, what's your duty to people that are on your property? I want to touch a little bit on trespassers. Daryl, you probably did you put your sign up yesterday that said trespassers will be shot, survivors will be shot again? Any other ones that you put up?
No, but that one got the point.
If you can read the sign, you're in range. You got that one up there?
Yeah, that's right.
Yeah, but people don't like trespassers, and it worries them to death. People ask stuff like, well, do you have to post your land? You don't have to post your land, but you ought to post your land. Somebody's still trespassing whether you posted it or not. So anybody arguing that they're not trespassing because you didn't have a no trespassing sign is just wrong. But it's smart to do that. And the other thing is, if you know somebody's been trespassing on your property and you warn them, and put that in writing, send an email, put a letter out and make a copy of it. But if you warn people, then in our laws and our statutes, there are like increasing penalties for trespass. One thing I'd tell you about this, if you want to solve a problem, this is a tough thing for landowners. You don't want to be that guy who's the jerk, that won't let the teenage kids come and fish in your pond and stuff like that. But the truth of the matter is if you get the reputation of he doesn't care, they don't care, then everybody's going to be on your place treating it like it's your own. So my experience has been, if you will warn people and make it clear that your property is posted and you will enforce it, you're not going to have a lot of problems. It's the nice guys that end up having the problems. And I know that's a difficult call to make, but the other thing that happens is a lot of times, you realize somebody's been hunting on your property or poaching a little bit or something like that, then these days with cell phones, it's very easy to get a license tag or take pictures. A lot of people are finding out they got trespassers because their game cameras that they're putting out on the trails are showing more than just the deer are all over their property, So you got to help the law enforcement folks out, because it's hard for them to catch these folks. By the time they get out there, a lot of times they're gone. So if you can, you don't necessarily want to have face-to-face confrontations with people you're not sure about, but get as much information as you can, and let your law enforcement people know that. The Mississippi Department of Wildlife, Fisheries, and Parks has a number to remember. It's 1-800-BE-SMART. Those numbers, if you can remember that, and you're out somewhere and you need some help, remember 1-800-BE-SMART, and you can maybe get some help to, help you with the trespasser. But again, you don't necessarily have a duty to keep that trespasser safe. One thing I'd warn you about, though, is there was a case I read years ago. I think it was called Dumas versus Pike County, and what it was on the Bogachitta River. You can rent these inner tubes and float down the creek, and lots of people do that. It's a lot of fun, but there's places on the sides where people get out, like what I call a redneck water slide. Where you got those clay embankments that get wet, and people kind of have their own water slide. Well, there was some place in there where people were routinely stopping. Sometimes, the testimony had more than 100 people in a day. And bottom line is, somebody on a clay embankment jumped off into the river and broke their neck, and ended up being a quadriplegic. I mean, it was just a horrible thing. Well, the family is dealing with horrible things when you get in that kind of expense. Well, they sued the landowner and said, well, you're liable with that. You should have posted warning signs. And he's like, what are you talking about? It's like, they're trespassing on my property. I don't have that. I don't have a duty to them. But the interesting thing was, after all the testimony, the court looked at this, and people were saying, well, look, there were well-worn footpaths. There were no warning signs. The landowner was well aware that for many, many years, people had been coming on this property, and that the conduct of the landowner could have been such as to have expressed consent to be there, which may have pushed them into a category being something more like a licensee or something like that, and were they somehow negligent. Now, that case didn't resolve the issue. It sent it back down to the trial court for more proceedings. They probably settled it. But my point is, you don't want to be playing crystal ball games trying to determine whether somebody is a licensee or an invitee or a trespasser. you'd rather err on the side of treating them like they've got a higher status. So if you're in doubt about something, I'd put warning signs up. I'd warn the trespassers. I'd post my property and deal accordingly. But let me tell you this. It's easy to listen to that and think, oh my gosh, this is just what I was afraid of. I'm going to get sued if somebody's on my property. That's really not what I see and been my experience in looking at our case law. There's not a whole lot of cases that you come across where somebody like you guys that have got property that lets somebody come out on your property, which really is just good policy. I mean, to let people get out and enjoy property, that you're getting held responsible because somebody tripped over a stump. And I say that lightly, but I remember going on a scout trip at one of these Cub Scout camps, and my own son, they're running around at night, and he trips over a stump hole and cuts his hand all up. And I've got to rush him to the hospital to get his hand all stitched up and everything like that. But that's not the landowner's fault. Those are just things that happen. That's that inherent risk of being on property. It's uneven surfaces. There's holes and there's stumps and there's logs and everything else. And nobody expects y'all to be picking every piece of that up when you're on raw land in rural forested land. So I'm trying to tell you not to panic about that.
So Mike, on that, if you don't mind me asking a question. So probably if you could go back in time, that landowner, when he noticed that there were foot trails and people diving off his property into the river, put posted signs on the property then and document that he had done that. And that would have been a good defense, in your opinion.
That would have,
look, you're not supposed to be there. That signs up, you're not supposed to be there.
Yeah, and there's no absolutes on any of this. I mean, we're going to get into the fact that one of the ways you're going to protect yourself is with insurance. I mean, you ought to have liability insurance. One of the best things about insurance is that it pays for your lawyers. I mean, you might be innocent, you might not have been negligent, but you can very easily go spend $25,000, $50,000 proving that you were not negligent. So did you win? You may not feel like that. So you definitely want to have that insurance in place that'll pick up your defense cost.
Another thing, Mike, just to mention to you, let you comment as I'm thinking out loud, and I don't know if this is with our good friends out here today, but since we've been doing these landowner workshops, I've just noticed in our survey work that about half our attendants are absentee landowners that don't live on the property. So where I'm going with that is, if you don't get back to your property often, might be another reason to have people at least checking on it. You go check on it, have posted signs like you're saying, or maybe if you got a neighbor that you like, lease it to them hunting, and that way it'd give you if you got property in Kemper County and live in Houston, Texas, I mean, they may be running all over.
It's a good point, and we'll get to that as well. But one of the key advantages people always tell you to leasing your property to maybe a hunting club or somebody that you trust is more than just the money. It's somebody to help you keep keep eyes on your place. And I'm sure you explained to them that anybody who thinks that somebody's not hunting their property is generally very much mistaken. I mean,
especially if you're not on it.
Somebody knows you're not there, and they see a big scrape over there and a good rub on the tree. Dang well they're going to be out there trying to figure out a way to, to shoot that big deer. But let's keep us in context. What I'm first trying to tell you is understanding your duty as a landowner, trespassers, licensees, and if you're going to, and so this is all about y'all trying to tell them you could make money on your putting people on the property. You could have wedding venues. You could, by the way, I got to tell you this. There's pages and pages. You can get this stuff online about all the agritourism businesses in Mississippi, and there's blueberry farms, and there's Christmas tree farms, and there's bed and breakfast, and corn mazes, and horseback riding, and paintball venues, and
zip line.
Yeah, and I'm looking at the way people advertise, and of course, you bring school kids are always looking for pumpkin patches and things of that nature. When you're young, you don't need glasses, and you get older, you need glasses, and then you start getting older. You get older than that. Now you got to take your glasses off to read, which is where I'm getting. You pick them, school tours, Easter egg hunts. You pick produce, straw mazes, corn mazes, Christmas venues and restored cabins, guided walking tours, birding, bird watching, and somebody in here has stargazing. So you can actually charge people to gaze at your stars on your property. And because people are just looking for things to do. They want to, I can tell you this is COVID era, everybody's looking for something to do. What better thing to do than ag tourism? Get out there and where you got a little bit of space. But so there's if you're going to be bringing people on your property, the point is you are going to be trying to profit from them being there. So you need to treat them like they're business invitees. And so you need to make sure your premises are reasonably safe. I'd document that if I were you. I'd take some notes and say, on so-and-so date, we went around and checked all our deer stands. And, because, one of the things people will do is, you don't have to do it year round, but if you've got a good place to hunt, you might, instead of just leasing your property outright to somebody, you might also do paid hunts. So you might specifically bring people in, really cater to them, cook for them, put them up, guide them out to where you want to go, and charge huge sums of money. It's unbelievable what people can make sometimes if they got decent opportunities for folks to come from down. Other states aren't like here. They got little short 1 month seasons, very limited. They got draw hunts. I mean, we kind of take Mississippi for granted, but we're open for business once hunting gets going, And so people will come down here and pay large sums of money to hunt for a weekend. And, what you need to do with that is just be clear to them what your expectations are. Maybe get them to sign liability waivers when they come down. That's one thing I would advise all y'all do. If you're looking at maybe having a for-profit venture, and if you go on a float ride on a river, you're going to do this anyway. Most people know this, but get like a liability waiver signed, a little one-pager that says, that as a condition of me being on your property for whatever, we describe whatever it is they're going to do, that, no promises are made by the landowner as to the condition of the property or of any of the roads, buildings, gates, or other improvements, and that my presence and activities on these premises expose me to dangerous conditions and risks, including, this is just typical lawyer and you get too many, poisonous snakes, insects and spiders, blinds and tree stands, whether or not erected by the lessor, erosion and general conditions of the land, deep water, persons with firearms that can be on the premises, and so forth and so on. But in consideration of my right to be on these premises, I hereby release and protect, indemnify, and hold harmless the landowner, or it could be the lessor, whatever the circumstances are, and his or her heirs, employees, agents, from any and all claims, demands, causes of action, or damages, including attorney's fees resulting from the accident. So it's not that hard just to get somebody to sign a liability waiver. And where I'm going with that is, but do that in the right circumstances. In other words, don't wait till it's 5:30 a.m. on the morning that you're going to go try to put somebody up in a deer stand. You should have, when they first called you, said, look, I'm going to send you some paperwork. I need you to sign a little contract for services. I'm going to send you a liability waiver, and that's going to make it easier for us to, be able to provide these things at a cost-effective manner. And they've had a right to say, I don't want to do that. In all likelihood, they're not going to have a problem with that. But, you just don't want to shove that under their nose after they've spent $3,500 to fly down from Chicago, to get on one of your deer stands. And getting back, the other thing is what I was trying to say is inspect your premises, document that. And, that trees grow and these ice storms come, and, things that were safe last year may not be safe this year. So be sure you're checking all that stuff out. If you're leasing to a hunting club, I would more than just setting forth the terms of what you're going to lease the property to them for. I get very much involved to some extent in how they're going to manage their property. If you want them being safe and checking stands, and I know that in our hunting club, our landowner requires every year that we inspect all the stands, make sure the chains aren't too tight, and readjust things and check all that stuff out. You just got to might want to insist with your hunting clubs that they're prioritizing safety, and they're following game rules. And it doesn't just have to be the state game rule. Well, we have requirements that we shoot a certain size buck. Are you going to let people shoot everything that walks, or are you going to maybe put some parameters on what kind of deer you want shot on your property? Those kind of things could impact, the value, that you have long term if you've got bigger deer. I hope y'all are sending questions as I'm talking about this.
I just answered one on insurance. Look at your chat box if you're interested in what I wrote.
By the way, I've got an application for liability insurance for one of the insurance companies, and you can learn a lot from looking at the questions that they ask. And so I'm looking through here and I see, okay, well, what all do y'all do? And one of the questions is, do you ask them to sign liability waivers? Well, do you think the answer to that might affect what your premium's going to be? I would say yes. You want to be the guy that said, yeah, we require liability waivers to be signed. Absolutely. I've heard people ask questions like, well, somebody told them those aren't worth the paper they're written on. You've heard people ask us that. I totally disagree with that. They are worth the paper they're written on. And, if somebody has been hurt and they go to see a lawyer and they're like, okay, look, man, I want to get after this landowner, or maybe it's the wife of the husband who fell out of the deer stand and now she's got to take care of a bunch of kids and ain't got the help.
She didn't want him hunting anyway.
That's right. She didn't. But they go see the lawyer. It's like, well, did he sign any papers, any liability waivers, things like that? It's like, I don't know. We'll find. That's gonna impact the value of that case. You want to put obstacles in place as you defend yourself. And so a waiver it's not the end all. That's not the end of the show. But you want to have that liability waiver. Now I tell people don't take that too far. I mean, if you've got a busload of kids that show up and one of them forgot their mommy didn't send their liability waiver with them the next day, you're not going to leave the kid on the bus. You're going to be glad you got 60 of the kids of the 61. So don't let the tail wag the dog. You're there to entertain people. Don't go too crazy with all the legal stuff, because you already understand that you're going to have to kind of do something wrong before you're going to get held liable in the first place. But you got this liability waiver, and moving on to more sophisticated things. One of the things you're going to consider is maybe setting up legal entities to help give you some protection. Now, as landowners, I know that a lot of you own the property outright in your name, maybe you and your wife's name, you and your brother's name. But I tell you, as a business lawyer, I spend a lot of time setting up corporations and limited liability companies, which are, as people are setting up businesses, and it's designed to give them some liability protection. So if I knew that I had 1,000 acres of land and I was going to start bringing people on and charging them to be on the property, I would put my property into an LLC. So I'd set up Massey Properties LLC, and I would have a deed drafted that takes it out of my name and puts it into my LLC. Now, I own my LLC. I'm essentially the owner. I might have multiple owners. I might have me and my wife. I might, a lot of you might have kids and are trying to figure out how to get them involved in the ownership and trying to do some estate planning. Well, LLCs are a great way to establish a single owner of the property, because you don't own the property personally anymore. Your LLC owns the property. You own the LLC, and you may have multiple members that own that LLC. But it can really help you out in terms of having the ability to sign documents or sign the paperwork you've got to get government subsidies and programs paid for. We run into a lot of problems when you can't round up all the landowners, especially with what's called like airship property. I can't tell you how many calls we get where people have let decades go by. They've had granddad died and their dad died, and they had 7 brothers and sisters, and 3 of them have passed away, and they got 17 nieces and nephews, and all of a sudden you look up and a 50-acre tract of property has now got 23 owners. Well, how are you going to do anything with that? I mean, it's just incredibly difficult to deal with that. So I'm just trying to tell you that if on the other hand, when there were 2 or 3 owners, you put the property into an LLC, Massey Properties, then when somebody dies, their descendants are just now going to be shareholders effectively in the entity. But the property is still owned the way it's still got a single owner, which is that LLC, and therefore a manager or the president or the board of directors or somebody that's got decision-making authority within that LLC can get things done, can actually even sign a lease. You can't even get a good lease signed if you don't get all the signatures from everybody. You can't have one person of 23 sign a valid lease of the property. It doesn't work that way. They don't own all the property. So I would think real hard, if you haven't done this, about maybe putting your property into a limited liability company and letting that, and then the biggest legal part of that is what's called an operating agreement. That's like your partnership agreement. So if you got 2 or 3, maybe your brothers or your siblings own some property, you're going to have this multi-page contract, and it's going to deal with matters like how we make decisions. You might appoint a manager or co-managers to deal with day-to-day decisions, to get the taxes on the prepaid, to pay the bank, to hire the guy to come bush hog the property, to get a fence fixed or a broken water line repaired, or what I'm calling day-to-day type things. Now, everything's not day-to-day. So if we were going to go borrow money for some reason, like the lake, well, that's a different deal. The manager doesn't make that decision. That ought to be something that the members, the owners, are deciding. And here again, you got to think in terms of, is it going to be a majority vote? If there's 3 of you, is 2 out of 3 going to be enough to make decisions, to cut the term, or to sell the property, or to admit a new member to the entity? Sometimes people will put what's called super majority provisions, meaning no, 50% isn't going to work for that. If we're going to bring in new people or do some big things, it's going to take a super majority. It may take unanimous consent before we're going to change any of these terms. But you got to be careful with things like unanimous consent, because you got 4 or 5 people in the ownership, and 4 of you want to do something, and 1 of you doesn't, then you're letting this 20% owner run the whole dang show. So you got to be careful about unanimous provisions. Now, if you're 50-50, obviously you're going to have to be unanimous, or you're never going to get anything done. So one of the big things when you have an LLC is how you're going to make decisions. Are you going to have a manager? Are you going to have co-managers? How much are they going to be able to do, and how many things are they not going to be able to do? If it comes to selling the property, or we're going to cut all the timber, or we're going to borrow money, or big type issues, we're going to need something more before you're going to make that decision, would be my thought. Are you going to have mandatory capital calls? What if you run short of money? Are we going to be able to require people to put more money into the entity? You got to be careful of that, because if you're the guy that doesn't have any money, and the other guys have all the money, may not mean anything to them. Say, no, we need to put more money in. Well, you might have provisions that could dilute you out of the ownership if you can't meet the capital contribution. So you got to think about, are we going to have mandatory capital calls, or is that something that we're going to have like unanimous? Like we're going to have to be unanimous before we put more money in. Most people are going to go with non-mandatory capital calls, but that if you're like a developer down in Jackson, Mississippi, fixing to develop 100 acres of land into a big neighborhood, and you're going to have mandatory capital calls, but that's investors. You're like rural property, so you might have some different considerations. What happens if something happens to one of you? What if one of you dies? Because that's the thing we're talking about anyway, is when people start passing away and creating heirship issues, you better have dealt with that. So a typical LLC provision might say something like this, is that if somebody were to pass away, then this is the question you got to ask, is you might give the company the right to buy that person's interest back, because you may not want to be partners with their wife. They're not your immediate blood family. Maybe I run into situations where I've had some situations where people have Mississippi land that goes all the way back to the patent. To when Mississippi was formed, and they feel this intense obligation to keep the property in the family. So you could have provisions that say if somebody dies, then the LLC has the right to buy that property back, maybe at fair market value as determined by a mutually agreeable appraiser, some mechanism to value that. Or you might be happy to let that person, let their property go to their kids or whatever else, but you just want to spell those things out in your operating agreement is what are we going to do if somebody passes away? Are we maybe going to take a look at buying some key man insurance that would allow us to have the money necessary to buy that person out? You may not have the ability to buy them out if you don't take care of things like that. So these are the things that your operating agreement controls. From a tax standpoint, this is an important point. I hope you all listen to this. Be very mindful not to put real property into corporations if you can possibly avoid it. Of course, a long time ago that we didn't have LLCs, and so I still see old entities where people have got valuable property stuck in a corporation, and they may want to get it out. They may want to set. I've got situations right now where I've got people that own operating businesses, and the partners somewhere along the way bought some property as an investment, maybe a hunting camp or something like that, and the property is owned by a corporation. Well, maybe they want to do a transaction with the corporation, but they don't want to sell their land. They want to keep that. Well, when property is in a corporation, it doesn't matter whether or not it's a traditional, what you call a C corporation, which pays corporate income taxes, or a subchapter S corporation, which means you don't pay corporate taxes. In a sub S corporation, all the income or the loss is accounted for, but it passes through. It's a pass-through entity, so the earnings or the losses pass through to the owners in proportionate amounts, and then the individuals pay the income taxes. So, two people owned an S corporation that made $100,000. They might both get a K-1 for $50,000 a piece, and then they report that individually and pay taxes on it. That's an S corp. A C corporation, on the other hand, would pay taxes in the corporation on that $100,000, and the money's still in the corp. Whatever's left is still in the corporation. So if you want to take it out in the form of a dividend or distribution, you're going to pay taxes again. So almost nobody that's a small business runs their operations anymore as a C corporation. They're normally going to be an S corporation. Now, large corporations, the Exxons and all the big guys, there's shareholder limits on who can be an S corp, and so they're forced to be a C corporation. Here's the point I'm trying to make to you, though. Don't put land and stuff into that corporation, because again, if you want to take the property out, this is what's going to happen. The IRS, if you try to take property, real property, meaning land, out of a corporation, they will tax you based on the fair market value of the property compared to what you bought it at. So what you bought it at might have been $1,000 an acre. Now it's worth $2,000 an acre. Well, simply by taking the property out of the corporation, you can have a capital gain that you have to pay taxes, and you don't even want to sell the property. You just want it out of the corporation for some reason. So if you're in an LLC, it's different than that. You can take that property out of an LLC, and it is not a taxable event just because you took it out. Now, if you sold the property in the LLC, then yeah, you're going to pay. You're going to have a capital gain. It's going to flow through to the shareholders. I'm just giving you a red flag. Anybody that's trying to convince you to put property into a corporation, you need to have a red flag. Say, no, better talk to my lawyer or talk to my CPA, because that's generally a bad idea. Let's see here. I want to just recap what we started out with, making sure you understand your obligations as a landowner. And that starts out with what's your duty to people. That's the trespasser, licensee, invitee concept. And then what are we going to do to minimize that liability? We're going to get liability waivers signed. We're going to get insurance, liability insurance. We're going to consider setting up legal entities that would give us an added measure of protection, so that even if you do get sued, and even if the insurance doesn't cover the problem, or that you've got $1 million limits, but you've got a $2 million problem, and now we're looking to that LLC to offer you additional protection, because if somebody has a claim, if you're that hunter that came down from Chicago, and you're dealing with Massey Outfitters LLC or Massey Properties LLC, then you've really got a claim against my LLC, but you don't have a claim against me personally. So if you get a judgment, you very well may take my property, but you're not going to take whatever other assets I have because you don't have a claim against me because you're not dealing with me. You're dealing with my company, my corporation, my LLC. That's an important distinction. And in more sophisticated planning, and I listened to you yesterday, I know you touched on this very lightly, but with people that do have very significant assets and we're trying to give even higher measures of protection, we might set up one entity that we're going to put the property in right here, Massey Properties, and then I may set up another entity over here called Massey Outfitters. And this is where I'm going to sign a contract, take your $3,500 for the weekend hunt. But this entity is not going to own the property. What I'm going to do is I'm going to draft a lease agreement, and this entity is going to lease it to this entity in an arm's length lease. And that lease is going to say that Massey Properties leases to Massey Outfitters 1,000 acres for $50,000 a year. You're going to pay me. And by the way, you can bring people, you can let people hunt out here, do whatever you want, but you're going to hold this entity harmless from anything that happens out there. So that's a contract. And we're saying that I'll lease the property to you. You pay me and I'll take care of the taxes and do all that kind of stuff. But I'm not involved in the operations here. You do whatever you want to do, but you're going to hold me harmless. You're going to get insurance to protect me. Let me tell you this on the insurance point while it's on my mind. If you're dealing with a hunting club or anybody that you're leasing the property to, you want to require them to have insurance. But that's not enough for them to have insurance because all that does is protect them. You want to insist and require in your contract that they name you, the landowner, as what's called an additional insured under the policy. So that if something does go wrong and you get sued, then you also have access to that insurance coverage. And even that's not enough because they may not do that. So if you're not verifying it, you're just being dumb. So you better also insist that they provide you proof that they did in fact obtain the insurance and that they did name you as an additional insured. And even that's not good enough because next year, when the premium comes up, they may not do it next year. So every year, you got to be making sure that they've gotten their insurance and named you as an additional insured as a condition of them leasing your property. But in any event, you're going to want to have insurance coverage that protects you. Gerald, did I miss anything in that little segment?
No, not all. Let me say, on the big point, what we're trying to do is we're back to this idea of two different entities. So under this scenario, if something has gone wrong and somebody fell out of the tree stand, they should have a claim with Massey Outfitters. And I'm going to have insurance, liability waivers. But what I'm not going to have is ownership of the land. So when they're looking for a big judgment, this entity is not going to have the assets. It's going to say, well, I don't own the land. I'll lease the land from another entity over here. So now I'm not telling you they're not going to try to figure out a way to say, oh, this is just all a bunch of sham. But the reality is that a properly formed entity in Mississippi has a separate identity apart from its owner. You're not one and the same as an entity that you own. It has a separate identification number, EIN number. That's an employer identification number. Mississippi case law makes clear that a properly established entity, that you're not commingling assets in, you're not doing stuff to treat it, you're not paying your mortgage payments out of your corporation and just treating it like some little backdoor insurance policy. You're gonna have liability protection. It says Mississippi case law, this is Mississippi Supreme Court. Mississippi case law generally favors maintaining corporate entities and avoiding attempts to pierce the corporate veil. When somebody tries to get through your corporate veil and still hold you responsible, that's called trying to pierce the corporate veil. The cardinal rule of corporate law is that a corporation possesses a legal existence separate and apart from that of its officers and shareholders. This rule applies whether those corporations are individuals or corporations. The court has held the concept of the corporation is that the distinct corporate entities will be maintained unless to do so would subvert the ends of justice. And
by that, there are exceptions where you can pierce a corporate veil. If people are committing fraud through a corporation, they're not going to be protected for fraudulent activities just because they had a corporation set up to do it. And there's other exceptions like that. But so all I'm trying to tell you is you can layer this protection, and where you're bringing people on your property could be like an outfitter. You could call yourself an outfitter. You hire your guides that you're going to need and things of that nature, but you may not own the land in that entity. At the very least, though, you'd at least like to have an LLC owning your land and dealing with the public if you can do that. So that's what I'm a corporate business lawyer. So a lot of what I do is I'm constantly setting up operating agreements, and they can be, relatively, not that complicated, or they can be real complicated. Some people have got a lot of property and they got a lot of considerations, and but that's what it takes. And you can also be a one-person LLC. Let me mention this. Without going to a whole lot of trouble, Mississippi now acknowledges that we have one-person LLC. So it used to be you had to be a partnership. That is no longer the case. And by the way, you can make an election, and this is what it's called, to be disregarded as a separate taxable entity. And what I mean by that is, instead of, if Massey Properties is a one-person LLC owned by Mike Massey, even though I've got this liability protection, I can just file a schedule on my Form 1040, which would be like Massey Properties LLC, and it's just like a Schedule C, like a business, simple business that I'm operating, and I don't have to do a complete separate income tax return, to do that. Now, if you're an S corporation, you will file a separate income tax return called Form 1120S. If you are a true partnership where you got more than one owner, you're going to file a Form 1065, which is a partnership tax return. I'll tell you this too, these days people are setting up LLCs, and even with an LLC, you can make an election to be taxed as an S corporation. And y'all thinking, well, you just told me you don't want to be taxed as an S corporation. That's not always the case. Sometimes, if you're going to own land, you want to be in an LLC and treat it as an LLC. But in this outfitter operation I've got over here, I might want that to be an S corporation. And why is that? Because let's say, same scenario, I made $50,000 in this outfitting business where I'm going to guide people around and do bird watching and all these different things. When you're self-employed, you pay what's called self-employment taxes. Anybody out there that's an employee, if you've ever been an employee, you get a W-2, and you pay about 7.5% to FICA, those Social Security taxes, but your employer matches that other 7.5%. So you pay half, the employer pays half. But when you're self-employed, you got to pay both half. So on that $50,000 of income you earn, you might be paying, in addition to your income taxes, your personal income taxes, you might also pay what's called self-employment taxes at 15%. Okay, now get this, if you are an S corporation, you can pay yourself what's called a reasonable salary. We could spend all day talking about what's a reasonable salary, but let's say that reasonable salary is $25,000. You're still going to get $50,000, but $25,000 of it you might treat as wages, but you might treat that other $25,000 as a distribution of profits from your business. And distribution of profits from an S corporation are not subject to these self-employment taxes. So you just missed paying 15% on $25,000, which puts several more $1,000s into your pocket by being an S corp. So there may be a real good reason to be a subchapter S corporation, but it's not a good place to own your land. So I guess the answer to all that is I don't think we've got enough time to cover why exactly which entity, but you do need to sit down with a lawyer or sit down with your CPA, and you're only going to have to do this one time and say, look, here's what I'm thinking about doing. What's the best way to organize this business? Because I don't want to pay any more taxes than I have to. I do want to have liability protection, so I don't want to just be a sole proprietor operating as Mike Massey, because if I do something wrong and I get sued, then I haven't protected myself, and all my assets are blowing in the wind. By using LLCs, you can isolate some liability. So
Yeah, Mike, a little bit different what you're talking about. Let's go back and kind of catch up just a little bit and let you take a drink of water again. Someone asked a question about back on hunting leases, and I thought it was a good one because it can be a source of problem back on liability issues. How to handle guests, and I guess, we talked about that a little bit yesterday. Think about that up front. If you're leasing to Mike Massey, how many guests can Mike bring? And that brings up, if you bring guests as a landowner, you want to get liability waivers. Just talk about a little bit of that.
So what we normally do on that is, that if you've got a hunting club or people leasing property, they're going to bring guests. I mean, it's very difficult to say you can't have guests, because pretty much anybody is a guest. But what we do is say, not only will y'all sign liability waivers as a contractual obligation, any guests that come will also be required to sign a liability waiver as a condition of hunting there. So, like in my own hunting club, our landlord requires that we secure those. And I don't know that we do that 100% of the time. We do the best we can to try to get the message to the members that if you bring a guest, make sure they sign a liability waiver. You get them the best you can, but you're not going to be able to necessarily police that as a landowner, but you want to have required that. And again, you're also going to have that provision that says you are going to bear responsibility for anything that happens, and that includes guests. And so if I get sued by a guest because they fell out of a tree stand, you're going to indemnify me for that. Now, when I say indemnify, that's like if it costs me anything, you're going to repay me. That doesn't do you much good if the people that are promising you don't have any money. And that's why you require them to have insurance to pay you. And that's why you verify that they have insurance, And so that's how you do that. You just deal with it the best way you can. And most hunting clubs are going to have some limits on how many guests, because people will abuse that. Every time you show up, they got 3 people bring them, and they're not paying. It's like you're taking more than your share of the pie. It's kind of the way eventually that gets to be, and it causes problems in hunting clubs when people abuse that. But, people are going to have guests from time to time. A lot of clubs will have rules where on certain days like opening day or Christmas weekend or New Year's, when you're going to have big groups, that you really try to limit the number of guests that are going to be there. But your insurance is going to protect you, and then you're certainly going to put it in your lease that you expect them to police their guests and get them to sign liability waivers. So that would help you out. What else is coming?
And just in finding what kind of insurance should hunters have? I think I answered a little bit of that. For example, I'm not touting flying their flag in Mississippi Forestry. So MFA in Mississippi, they offer insurance for hunters. They also offer insurance, particularly for landowners, and also for landowners that are just wanting to recreationally hunt their own. If you have a family members and you just personally recreate, you can have insurance that way as well. So ask your insurance provider, Mike, when you say if they can write a policy for you. If they can't, you can find sources. One thing we got into, not to take anything from Mike's comment, but at one time agritourism was kind of a new thing, and policies weren't available for that. But now that's more common practice, and you can.
I agree. I think that it's actually, the cost maybe has gotten a little less prohibitive than it used to be, because it was sort of a new thing and everybody's a little bit nervous about it. But that's one of the reasons. Daryl, has been down. He's been advocating this for years. Went down to the state legislature and has spoken in front of them about these. We've both done that before, but I think that may have had something to do with them eventually passing some agritourism protection. You remember at the very beginning of the talk, I was telling you that there's an agritourism statute. And if you will fill out some paperwork and pay a fee, you can get listed as an agritourism professional. They'll come out and look at your premises, and you can also get signage. I think that's actually maybe the highway department that does, but out on the highways, it may lead to you having some signage, which could be very valuable to you, that's letting them know that there's an agritourism venue that you may be operating. So look, it's good. This is a growing thing in Mississippi. I mean, we've got this beautiful land. We're absolutely a forestry, agritourism, you know, we do, I mean, the only reason I'm working mainly is to buy fishing bait and shotgun shells. I mean, otherwise, what have we been doing right there? So everybody here loves the outdoors, and I think we're just beginning to realize how much demand there is for people to do things like that. Look, all these elementary schools want to do this. There's a little 40-acre Christmas tree farm we went into one time over in Louisiana. What was it, Monroe? Where was that?
Outside of Monroe, yeah.
But I couldn't believe, 40 acres, and this guy tells us that he has as many as 20,000 kids a year that come out to this Christmas tree farm. Now, what he did, they hooked up old tractors, and not tractors, but like almost lawnmowers, and make do trains, you know, and you've been to those Chuck E. Cheese places where, you know, the kids are all jumping around in the big thing of balls. Well, they do the same thing, but they do it with like having like big corn bins, and they're playing in the corn, and they're just making fun things to kids to do. They pay $6 a piece just to come out there, and they'll have a gift shop. They'll sell stuff, but on 40 acres, 20,000 kids times $6 is $120,000 just to entertain kids.
Right.
You know, and then they'll have add-ons if you want to ride this ride or do that kind of thing. What's it, Michael Mays over at Lazy Acres and over close to Meridian, in Chunky, Mississippi. You talking about the slingshot?
That Bull Bottom Farms has a corn cannon. It really shoots hard.
Well, this guy's got this big old slingshot. He has targets down range. They shoot those little pumpkins. You know, these pumpkin patches, they're not growing the pumpkins. They're just bringing out a big load of these little pumpkins, and the kids don't know the difference. So they're just picking a pumpkin. Now, there may be some real pumpkins too, but they got this little slingshot, and Michael says the kids can't play with it because the adults won't let them. You know, they're out there having fun. So zip lines, corn cannons, the mazes, the bonfires. It's just as creative as you want to be. Like bird watching has always cracked me up. I mean, because I have found that I'm a bird watcher. This past week with all the ice and the snow, with nowhere to go, I don't know how many hours I spent just watching my birds. I mean, I've got 4 cats and a dog, and I swear I spend way more money on bird seed than I do feeding all those other animals combined, you know. But I like watching birds. But
birds have been in trouble with all this ice storm too.
But you know, what we found is that people might take a hunting property where you've got a well-defined system of trails, and our hunting camps like that. We got great trails. Our landowner invested in bridges long ago, and you can move around. But you know, I'm always interested, as I'm bored on a deer stand watching a woodpecker or something cool that happens around you. But there's people that just like to do that, and they will pay you maybe to come on your property and use those same stands and move around. And did you tell about out in California? We hear stories about folks that you know, have these, you know, kind of combine that wine country and bird watching, and you know, they might stop at one spot, and they got a little door in a tree, and you know, maybe a glass of Merlot in there for them to drink, and then they move on and have some Cabernet and Pinot Grigio on around the route. They're doing pretty good just to finish the bird watch by the time they get done. So they're just entertaining their patrons. So however creative you can be to put people on your property, and you got to look at every feature and figure out what you've got that's fun. And I tell you, these guys are great at that. So if you think you may have a venue, call Daryl and his crew and your extension folks, and they would love to come out there and maybe help you figure out what might be viable on your property. I mean, you know, it's just not the same for everybody. If you just got a pine thicket of 3 or 4 year old trees, there ain't going to be a whole lot you can do with that. It's going to be even hard to deer hunt it unless you can get up above it. You know, other people have beautiful hardwoods. You might have the ability to float down the Big Black. You know, where I'm at, we're on the Big Black, and you know, nobody can hardly get back to the place to fish it. We got 1 or 2 fishermen that come in there, and they'll catch 50 or 60 2-3 pound, 4 pound bass when they come in there, because it's just, what do you got to do? You know, we go out west and we'll go horseback riding in Wyoming, or go on an elk hunt, or go fly fishing. Well, those folks can come bass fishing, or you can take them jug fishing for catfish, you know, something kind of more what we do. It's just however creative you can be. So, all right, we're talking. I get rambling, so I want to get back. We talked about duty, liability, protection mechanisms. and I want to touch on just leases in general. Leases are contracts, and so let me talk to you a little bit about contract law. Be careful that if you enter a lease to lease your property to somebody, or maybe you're leasing property from somebody, you need to carefully identify who the parties to the contract are. Don't sign a lease with 2 of the owners when there's 4 of the owners. Get all of them to sign. Don't deal with the ABC Hunting Club when you find out that it's not even an incorporated entity. And Daryl wants to sign as the president of the ABC Hunting Club. You can go on the Mississippi Secretary of State's website and it'll tell you whether or not that is a legitimate entity or not. And if it is, then you can have an officer speaking for the club. But if it's just a group of guys calling them a hunting club, that doesn't make them a legal entity. And Mississippi does not recognize unincorporated associations. That's what a lot of hunting clubs are. So a lot of times with my landowners will require, because they want to say that, Mike, I don't really have a good lease in place. We're just kind of shaking hands and signing a document. And getting a check. What do I do? So let's just put a lease agreement. Let's make sure that they got the liability on them, like I've been talking about. They got insurance, and we may have to require that they get organized so that there's somebody that actually is a hunting club. Now, that doesn't need to be a for-profit corporation. It should probably be a not-for-profit corporation, so they don't have a lot of worries about tax filings or things of that nature. So you can form a hunting club as a not-for-profit entity. As opposed to an LLC or something like that. Now, I think we made a mistake with our club. Years ago, this was formed as an LLC, and all we're doing is putting enough money in our club to pay the dues and the gas and the insurance and all those kind of things. But the problem is, because we're an LLC, we have to do a tax return every year. And so nobody can finish their personal tax return until they get a K-1, their partner share that's going to say they made $12 last year or they lost $12 last year. So that wasn't really good planning to do it that way. So to me, it's a better idea to form a hunting club as just a not-for-profit entity, unless, of course, you're going to own the land. So, if you're in a club that owns its property, then by all means, you're going to set up an LLC because you are there for profit. So you're going to get those you're going to make sure you know who the parties are. You might have to get some minutes and make sure that whoever you're signing a lease with has the authority to sign for everybody. And again, regardless of whether I'm signing with a president to get a hunting lease into place with a hunting club and he's got 25 members, I'm still going to require that he gets every one of those members to sign a liability waiver and send it back to us. So I'm going to police that. That's a big part of that. But you're going to be clear about the land that you're leasing. Their access. I've seen a couple questions pop up about easements. Be careful about easements. If you need easements to get to, don't go sign a lease on property and find out you can't get to the property in your land lot. So if you need to deal with easements, deal with it. I've seen hunting clubs that the people they had to get across to get to the hunting land don't want them crossing all hours of the day because they're hunting. So they might have provisions that you're going to be in the woods before 6 a.m. or 6:30, and you're not going to come out before 10 because I don't want you driving a truck through the middle of my food plot when I'm hunting on a stand at 8:30 in the morning. So those are things you might want to work into your lease. If you are a hunting club or somebody who's leasing property and you decide you're going to get on a piece of property, make a commitment, start managing the property, hunting the right kind of deer, planting food plots, what you don't want to happen is that the guy off the street comes along and offers your landowner another $1 per acre and lease it out from underneath you. So you might, in your lease agreement, want to negotiate what's called like a right of first refusal, which says if you should ever want to entertain another offer for the property, you're going to give us a right to at least match that offer. So at least you'd have the opportunity to pay that extra $1 and maybe say, well, I'll pay $150. Okay, then I want to match $150. But you just don't, you want to put mechanisms in place to keep somebody from just, maybe stealing something out from underneath you. Again, you want to be clear about the parties. Don't get paid at the end of the season. Don't even get paid the day the season starts. Because if all of a sudden it's opening day of deer season, you're expecting your check, and the guy says, man, I had a few people flake out. I'm not going to be able to do it this year. Well, you're out of luck because the hunting season has started. Everybody else that hunts, they're not going to wait till the day of hunting season to go find somewhere to hunt. So you all of a sudden are going to have no money coming in. What you should have done is gotten your first payment 3 months ahead of time, for instance. You know, the first payment will come due 3 months ahead of time. The last payment will come due the first day of the hunting season. So at least if something like that were to happen, you know, they got some skin in the game at that point. So don't wait until hunting season starts to get paid. Be clear about what you expect of the landowners in terms, if they're expected to maintain fire lanes and roads, because I have a lot of people that get mad because they are rutting up the roads, just tearing the crap up, littering, all kinds of things that aggravate landowners. So you be clear about what you expect from people who are leasing your property. And
that would be in the lease. Would you agree?
In the lease agreement, these are lease terms that I'm trying to put in. So be clear about what you expect of them. Be clear about the fact that you're waiving any lot. I'm not promising you anything. You're taking the property as is, where it is. I'm not doing anything out here. And so if you're going to come on this property, you're accepting this property as is. You're holding me harmless. You're going to get liability waiver signed. You're going to indemnify me. You're going to get insurance that names me as additional insured. These are the terms of a lease agreement, and be careful about just printing something off online or Googling you up a form, because land is just fundamental to lawyers that all land is different. It's unique. There's no two pieces of land exactly the same, and so your particular property probably has some special considerations you need to deal with. You may have a clubhouse that you're also going to lease to them. I mean, how's that going to work? Or how's it going to be maintained? Whose responsibility is it to fix things when they break? Like in our situation, I'll just give you ours again. We've got a clubhouse, and it's a big fancy clubhouse. Certain things are the responsibility of the landlord, and some are ours. I mean, you know, you would expect the roof to be leaking, or you might expect that the air conditioning unit and HVAC would work, or things of that nature. But you know, you might not expect the landowner to change your light bulbs every time the light bulb goes out. Or, you know, what do you do like this past week? These kind of things are real. Nobody's at the hunting club, and now we got 10-degree temperatures. You reckon some people got some frozen pipes in hunting clubs? I guarantee you some people looking at leases right now trying to figure out whose bad was that. Now, you know, good planning would tell you, you better get somebody up there and turn the water faucets on, and you better make sure the
Drain your
heaters
pipes.
are on.
Drain your pipes.
Well, I mean, it's different for everybody, but those are the kind of things that if you just print you off a form and you don't put a little thought into it, are going to bite you in the butt before it's over and done with.
Mike, I was going to mention the tag team. Were you there? And I mentioned it yesterday, and I won't try to show you, but on the brochure you got for the webinar, I'm going somewhere with this, my website, Natural Resource Enterprises, that website is for you there. Go to that. There's a lot of good information there. Under business resources, getting to what Mike was talking about, go to business resources and click on hunting lease. And he and I, mostly me maybe, but put out a publication about hunting leases. On the back of that publication, there is kind of a template of a hunting lease. And again, what Mike was saying, don't use that verbatim.
Well, I made him put a big disclaimer. It's like, you know,
my attorney's protecting me.
It's a good form, but it's not, you know, you just want to make sure that you sat down with somebody. I would tell you, don't play lawyer. Actually, those are my best clients, just to be honest with you. The people who play lawyer, I make a whole lot more money with those guys than the ones that'll call me ahead of time and say, look, Mike, I'm thinking about signing. You wouldn't believe how many times somebody comes to me and says, like, I want you to look at this contract I signed yesterday. I'm like, you signed it? I was like, well, what do you want me to look at it for? I mean, it's too late at that point, but you'd be surprised, you know? So it doesn't, in terms of this planning here, what I'm suggesting to you is, unless you're very comfortable with what you're doing, it wouldn't hurt you to get your lawyer or your accountant or somebody to sit down on the front end. You don't have to do a new corporation every year, a new operating agreement. A lot of these are one-time kind of setup fees. Get your forms in place. By the way, if you are going to bring people on your property, there's an agreement. They're paying you for something. They're paying you. What are they paying you for? You know, you want to spell that out. Well, here's what I'm going to do for you. I'm not guaranteeing you're going to shoot a deer. Don't get mad when you don't shoot a deer. I'm not selling you a deer. I'm selling you an experience. I mean, they may come down here and it's raining the whole time, or, you know, the deer aren't moving, the fish aren't biting. So in addition to saying what you're going to do, say what you're not going to do. You know, be clear about that, and you'll solve a lot of problems in that regard. So that's an agreement that you would have with them. I put that in writing. I wouldn't just handshake on it or something, because you run the possibility of them being dissatisfied. And again, I wouldn't look to get paid at the end of the hunt either. I want to get paid up front before I'm going to go spend my time, because you can't get your time back. You know.
It's interesting what Mike said, just in case I'm chasing a rabbit here a little bit, but somebody, I'm not selling you a deer. To remind everyone, wildlife in Mississippi is owned by the state. I own my land, and I have access to my land, or can rent access to my land, but I don't own the turkeys on the property. So that I'm just mentioning that to you. Now, one of the issues, and I don't mean to step on anybody's toes here, but one of the issues the state's dealing with, and when I'm not going to open this can of worms, but I'll say it, high fence operations where you can keep white-tailed deer in an enclosure. Legally, the state owns the deer, but when they're in an enclosure, they can't leave. So that throws up some legal issues. Just mentioning that to you, that wildlife is owned by the state as a public trust commodity, or a public trust doctrine, and I own my land, so I can hunt the turkeys on my property. So that's just a kind of interesting point.
Yeah, there's all kinds of stuff. Let me tell you one other thing. I want to mention this airship issue again, because
we had a question on airship.
We did. Okay. Well, one thing I want to tell you is, and I talked to Senator Jennifer Branning, who's a good friend of mine. We do a lot of work together. She's from Philadelphia, and she's also an attorney. But I was asking her, what's new, or what have you seen lately that might be of any interest to these folks in terms of, timber, forestry, ag, anything? And she mentioned last year there was an airship statute passed, which supposedly was to help streamline the process, where if you look up and all of a sudden you've got 40 heirs to property, you don't know what to do. There's a statutory process that somebody can file a petition. You're going to have to post notice on the property to try to you'd probably have to do publication in a local newspaper, but eventually you would establish a hearing date for people to show up if they're laying claim to this property, and have a judge adjudicate that these are in fact the owners of the property. Now, we've always had airship statutes, but this can be just for a piece of land. And I'm not sure, please don't hear me that there's some simplified way to do that. That's the intent. I'm not sure it's as simple as that, but the legislature is trying, because they're recognizing it's a problem, is how much airship property we have. And that normally comes about again because somebody doesn't probate an estate like that. And what that means is if I die without a will and nobody probates my estate, whatever I owned in my name, and this is going to start bleeding into this estate planning section, which is the last thing we're going to do, it's going to be owned by my spouse and my children in equal shares. And if one of my children had died, but my child had children, then they're going to step into the shoes. But these are the laws of intestate succession in Mississippi. But what I'm telling you is that a lot of times in large families, maybe they couldn't afford to probate the estate and hire a lawyer to say, Your Honor, Mr. Johnson died. He had a wife and 4 kids, and he had this 40-acre tract of property, and we just want to make sure that, that you've established that is the way it is, and that they are now the owners of the property. Well, that doesn't happen. And so you don't know whether he had a will that left it all to his wife or not. It never got probated. So if in the absence of a will, we're going to assume that we're going on the laws of intestate succession, but all of a sudden some of those people died. So all of a sudden 70 years has gone by, and you've got this multitude of people. And you just can't get anybody. And then there's always somebody that we'll get these calls that like, I want to fix a lot of money. And that person just is a bit owner of the thing. So where's the money going to come from? Unless you're going to just loan it to the group, it becomes very problematic. So I guess the one thing I would tell you is whatever your situation is, and it may seem unwieldy to you right now, it's not going to get better. It's as good as it's going to get right now. So you might as well deal with it while you still can. And
I've got property in our family like that. I don't know how we're going to ever.
Well, it ain't going to get easier. So you might as well deal with it now, because it's not going to get any easier. But that's probably a good segue for me to.
Can I ask you one quick question before you get to? And we've gone on, Mike, I asked you, we've been on an hour and 15 minutes. If y'all are okay with that, we're gonna still do estate planning. Show of hands, everybody still okay with, y'all wanna hear more?
You can leave if you don't.
Okay, yeah, you can leave. We don't wanna wear you completely out, but, this is good stuff, and where are you gonna get this caliber of legal mind and for free?
Yeah.
One quick question, yes, more, I see, okay, yes, from Mr. Ellis. One thing before you get to the state, we'll go back maybe 10 to 15 more minutes, Mike, and
Maybe
maybe,
that take that long.
can minors sign a waiver? We got a question up here. Can a liability waiver be signed by a minor?
That sounds like a trick question. Yeah, they can sign it. It's not gonna be legally effective.
I think that's what he would.
You're gonna want their guardian to sign on their behalf. By the way, one question there, I was talking to Senator Branning a little while ago. There's a couple things that are floating around right now. One is they're considering raising the weight limits on taking timber off your property. Apparently we got the lowest weight limits of any of the states around here. I don't remember if you told me if it's
You mean at one time or in one load?
How heavy the trucks can be coming, hauling
That's
on the property.
That's gonna tear up more roads.
That's the argument, but we are lower than everybody else. And so there are people out of state that want to come into the state and establish operations, and they're considering raising the weight limits a little bit. So if y'all are interested in that, you might want to let your local legislatures know, because that's up right now. And I apologize for not knowing this. I don't remember if she told me it's 82,000 right now, and they're looking to try to raise it to 86,000 or something that's more in line. And that means that, you can more quickly, you don't have to make as many loads to get your timber off your property. It's because people have a lot of trouble a lot of times with logging things that they want to.
Right.
Another thing is there's something that's come up where if you leave land you may not have planned it, but it may be that a minor has all of a sudden inherited land. Maybe their parent died, and now you got a minor that also, how do you do anything with that? So there's some provisions for you. It complicates things because you have to establish a guardianship. You have to go to Chancery Court, establish a guardianship where somebody can act on behalf of that minor and make decisions about maybe the property should be sold or things of that nature. Let's do this right quick, just so you know, and I already touched on it. And I know you're landowners, you may have inherited property, you may have 3 kids and 2 of them are in California, and you got one that's here, and you're not sure about what's going to happen to your property. So let's just understand what happens if you don't do anything. Like I said, if you die without a will, then whatever assets are in your name are going to pass to your spouse and to your children in equal shares. Now, a lot of times that surprises the spouse. The spouse thinking, it's coming to me. It's going to take care of me in my retirement. Now, when I pass away, it's going to go to the kids. That is not correct. And that is why people do wills to fix that exact problem. You can now, if you do a will, you can say, I want everything to go to my spouse to see her through retirement. But if she were to die before I do, then I want it to all go to the 3 kids. And maybe the wife would do the same thing. She said, I want everything to go to my husband. But if my husband would die before I do, then I want it to go to the kids. Now, let me tell you this. This is something I was thinking about is I deal with a lot of people sometimes that are in second marriages. Maybe they have all their kids by the first marriage, but they got divorced, they're remarried, and they'll come and they'll get these wills done, and they're trying to take care of their second wife and be fair to their second wife, but they've also got these kids that they've had all their lives, and the kids are nervous that the second wife's going to take advantage of dad and get his land or something like that. So second marriages can put a lot of pressure on doing some good estate planning, but here's the point I'm trying to tell you is that you might assume that since y'all both got wills done, you got all that covered. A will doesn't mean anything until the day you die. If you got a will, or your wife has a will, by the way, that you think leaves everything to you, all she's got to do is tear it up and throw it in the garbage can and go do her a new will. And she might not even need to do a new will. If she's got kids, and all of a sudden you got a bunch of stuff in her name, and she passes away, that will that you thought was going to send some stuff on to your kids may not ever happen, because the will just gets torn up, and then it's going to pass to her kids. So if you want to be sure your property is going where you want it to go, you might have to set up some trust provisions in your will that might say something like, in the event of my death, I want to put this land in trust and I want my wife to earn all the income from it during her lifetime. But when she passes away, then I want it to go on and go to my kids. You know, you can do things like that. But if you don't address wills, it's just going to go a child share to my spouse and the rest to the rest of the kids. And you may end up doing something that doesn't really work out well for you there. So if you sit down with a will, you can decide what's going to happen to your land. You know, and you may need some trust provision. You may have a special needs child that needs some extra help that you know you're going to need a trust set up. And all a trust is, I know you hear that term, if you're not sure, and I apologize, I know a lot of you know this already, but a trust basically says, instead of me just giving my land to somebody, what I'm really going to do is I trust Daryl. He's a good financial manager. Or my brother's a CPA, or I got some kids that are in drug rehab, or whatever the case might be that worries you. You can put assets in a trust, and it can be in your will. It can be just a little paragraph that says, with respect to this $100,000 or this piece of land, I want to put it in trust. I want Daryl to be the trustee. That's the person who's going to make decisions. And the beneficiary is my child who's had some trouble or has some special needs or isn't able to manage their money or is in a crappy marriage which is fixing to fall apart or whatever. Everybody's got these kind of issues, and it can say that I want her to get all the income, and you make the decision on what she needs to take care of her health and her education and her maintenance and her welfare. And I'm giving you pretty much ultimate discretion on that until she reaches a certain age, for instance. I mean, it might be that it's a minor child, and I just want them to have their assets in trust till they're old enough to spend it. And that ain't necessarily 21 anymore, by the way. These days, somebody might be a sophomore in college at 21.
Right.
You know, so a lot of times people will say, if one of my minor children inherits anything, I want to put their inheritance in trust and maybe disperse it a third at age 25 and a third at 30, and the other third at maybe 35, where they've had an opportunity to mature a little bit to handle the money, or even longer term. But the trust says, I want you to manage the money. It's not your money, but I want you to manage it for the benefit of my child. And then if something happens to my child, then I've got alternate beneficiaries. Or once they reach a certain age, I want it to go to them. Or if it gets such a small amount that it's no longer practical to treat it like a trust, then go ahead and you've got the discretion to just pay the trust out. That's a trust. But in the context of land, you might have a really large asset. And I want to put that in trust, and I want you to manage it. You hire the foresters, you make decisions on cutting, and I don't want it to come out of trust. I want it to stay for the benefit of this family. And so I'm setting this thing up, and there's 4 beneficiaries. And if we cut $1 million of timber, then you can disperse it out to them, you know, or whatever you want to do. But I want to keep it together. And here's the other thing: if property is in trust, then somebody can't spend it and they can't go use it to borrow to get a loan and pledge it as collateral. You can put what's called spendthrift provisions that say no beneficiary shall have the right to encumber the property, which means pledge it for, to cover a debt or spend their part of it, or because they don't own it. And so you can't take something that they don't own, you know. By the way, an LLC that I mentioned to you earlier has got some of these same benefits. It's like I put provisions in LLCs that say, this started out, I used to hear a lot about this years ago when doctors were using this. We were hearing all about the medical crisis in Mississippi and every doctors leaving and all these huge verdicts before they came along with tort reform and all that stuff. And so a lot of doctors would put their investment assets into an LLC and add their wife as an owner. So it's a 50-50 owner. Remember we talked about how you admit new members? Well, the provisions will say no new members can be admitted to this LLC without the unanimous consent of the members. And so if the doctor committed malpractice, somebody shows up with $1 million verdict looking for assets, and they find this LLC, you think, okay, well, I'm fixing on your half of that LLC. No, you're not. Because there's an operating agreement that says no new members shall be admitted to the LLC without the consent of the other members. And guess what? Hell may freeze over before my wife consents to you getting that interest. And so instead, a judgment, somebody's gotten a judgment, would get what's called a charging order. And what a charging order says is, okay, I got a judgment for $1 million. And when and if you ever pay 1 penny out of that LLC, I'm going to be standing here with my hand open to get my 50%. But again, then you might just sit there a long time and say, listen, maybe I can scrape together X dollars to get you settled out here. Why don't we get that done? But at least you protected that asset. So again, trust are a mechanism maybe to protect your kids or keep the property in the family. You've got to decide who you want the executor of your will to be. That's the person who'll go see Mike, who'll go see the lawyer and say, look, what do I need to do? I need to get my dad's estate, I need to get this estate probated. The executor does that, but always pick an alternate. So you might pick your wife, but what if your wife dies before you do? Then you need to have an alternate. So you might pick your trusted son to be the alternate, or vice versa. If you have a trust provision, you got to designate who the trustee is, and again, have an alternate. Don't just go with one. Always make sure you got a second choice. If you're a young person that's got young children, you might want to designate who your guardian of your children would be. You can put that in your will. It's like, look, if something were to happen to me and my husband, I want his sister, I want my sister, I want my mom, his mom. Who's going to be the guardian? So if you're young and got young children, you might want to consider putting guardian provisions and an alternate, again, just in case. So a will is just a way that you can control what's going to happen to your estate rather than just happening automatically. I will tell you this: if you can do a will yourself. I wouldn't tell you to do that. I'd rather you go see a lawyer and do it right. But if you'll sit down on a piece of paper in your own handwriting and say, I'm Mike Massey.
Sounds like a fire alarm.
That's just a bell. Is that a fire alarm?
Keep talking, maybe. When we smell smoke, we'll
Y'all
leave
see
the room.
smoke, somebody shake your hand or something like that. But it's a little distracting when you got a fire alarm going off. So
yeah.
if you do a will in your own handwriting, say, look, I'll leave everything I have to my wife, but if my wife predeceases me, then to my kids, sign Mike Massey on this blankety blank date. That's a valid will, but it's got to be in your handwriting. If you can't type it out and sign it, that does not work. If you're going to do that, it's got to be in your handwriting. Better scenario would be go talk to a lawyer.
I was just going to say, Mike, too, on the trust, back on the trust part, to echo what you're saying. I was a banker in another life, and I remember people would have trust. I'm going somewhere with this, and what you said about, you can think about the age of the trustees and when we would see, and I was a young man at the time, but I would see where people had worked all their lives, build up an estate, build up money, and then it go to a young person. And I don't mean that against young people, but it go to a young person, they burn through it in 2 weeks. And it was set up that way. The bank couldn't do anything about it. So, but you talked about that. Think about that. And
one point on that. I'm so glad you said it. One thing, everybody, be mindful that I'm talking about assets in your name. How you own your assets is vitally important. So if you and your wife own property and it's joint ownership with rights of survivorship, then when you die, that property is automatically owned by your wife. So I'm only talking about things that are in my name alone. If you have property that is jointly owned with rights of survivorship, now there's something called that's a joint tenancy, the rights of survivorship. There's also something called a joint tenancy in common. If it's a joint tenancy in common, then it doesn't automatically go to the wife. It goes according to my estate plan, my will, the laws of intestacy. So if you and your brother own property and y'all both have kids, you're not going to own it joint with rights of survivorship. You're probably going to own it as a joint tenancy in common, so that your half would go to your immediate family and his would go to his immediate family. If you have a checking account and it says POD, payable on death to somebody, your will doesn't have anything to say with that. This causes a lot of problems when I'm probating estates, because mom has a $100,000 checking account and she put her trusted daughter, who's been taking care of her, seeing about her, as POD, with the idea that I just wanted her to be there to make sure she could write checks on my account. Well, guess what? When mom dies, that money is owned by that child if it's payable on death or if it was jointly owned. And so a lot of people think that their will is going to give it in thirds. And all of a sudden, that's not the case. And now maybe they're thinking, well, that daughter will do the right thing and split it up between everybody. But that daughter might think, no, that's what mom intended. I was one that took care of her all these years. Well, y'all were out in California doing your thing, and I was in here taking care of her. So you need to understand. And if you got an insurance policy with a beneficiary, it automatically goes there. Doesn't matter what your will says. If you've got a stock account, mutual funds that are jointly owned with somebody, that's where it's going to go. Payable on death. 401k plans that have beneficiaries, all these things are going to pass. Doesn't matter what your will says about it. So all I'm talking about is assets, though, that are in your name, like your land or your LLC. That would be an asset. That your 50% ownership would be an asset in your name. So in your estate planning, you need to consider how the property is owned. So it's not enough just to do a will and think that you got it all covered. You've got to take a look at every asset. And what I tell people to do is you get you a 3-ring binder and you gather every deed and get a copy of your account statement and start getting your files together, because most people just don't ever do that. And I'll tell you something else that's important now. I'm glad I'm thinking about this is these days, because of the cell phone, everybody has got cell phones and computers, and everything you've got has got passwords on it, and nobody knows what they are. So now, a lot of times, these technology companies won't deal with somebody that doesn't have that hadn't been designated. So you better make sure you got all your passwords written down somewhere where somebody could even access, where you may have all your photos and things that are important to you. You know,
some big wealthy person here recently had Bitcoin, which I know nothing about, everyone, much, but forgot their password, and there was no way to get to the Bitcoin anymore. He lost all of it. So, but that's a good point. Put it in a 3-ring binder, and you got it. And one quick question, we may just kind of come in for a landing here, and you touched on this. Do I need to file anything with the LLC, with the Secretary of State, to keep my business on?
Yeah, you'll have every year on
this question.
Corporations and LLCs, you're supposed to do what's called a corporate annual report, and if you don't do it, and it's nothing to it, it's just a matter of, yeah, this is still our address, these are still the owners. It'll take you 2 minutes to do it, but if you don't do it and enough time goes by, they will disqualify your business from, they'll basically just shut your company down as if you don't exist. So you don't want that. You can get reinstated, but you don't want to run into that problem. There is one more consideration I want to say here, and this is a tax issue. A lot of people are worried that it's going to be a lot of trouble to probate their estate. And so 2 weeks before they die, they're like, look, I'm going to go ahead, I'm just going to deed my property to my children and take care of that right now. Here's the problem with that, is if you bought that property, or you inherited that property 50 years ago at $200 an acre, and now it's worth $2,000 an acre, then when you gift that property to your kids to avoid spending $4,000 or $5,000 to probate the estate, your parent just gave you their basis on the property, which is $200. And so if you would have waited and just inherited the property at the time of death, then you get a step up in basis to fair market value at the date of death. So now your basis on the property would be $2,000. It's worth $2,000. So if you sell it for $2,000, you know how much tax you pay? Zero, because there's no gain. But if you think you're outsmarting somebody to get a parent to go ahead and deed you the property before they die, you just inherited their basis. So now you got an $1,800 per acre capital gain, and you're going to lose a fortune paying taxes. So don't anytime you start seeing like, oh, we're just going to get mom to transfer the property to us right now.
Don't do that.
That's another red mistake where it would have been better, maybe some better mechanisms to deal with that. A lot of things. You know, we could stay here all day, and we're going to, I know I can't do this all day, but what I'll leave you with here is that spend a little time with your professional, get your deeds together and think about your situation. Don't panic about liability. This whole thing started out because we know you like the idea maybe of opening up your property, maybe making some more money. I would not panic. There's too many things you can do to protect yourself. You know, don't let the tail wag the dog. As creative as you can be on your property, and it may be something you really enjoy as you reach retirement. You want to have kids out on your property and give them an opportunity to do that. It might be something really fulfilling for you. And if you'll just take some common sense steps like we're talking about here, I think you could get real comfortable, as to how to protect your land. Don't keep putting off getting your wills done. And if I ask for a show of hands, y'all would all be embarrassed, because I know that less than half of you are going to have wills done in all likelihood. And when you do a lot of this, you wonder about that, and a lot of people have still not accepted the fact that they're not going to be here forever. They don't really want to deal with it. But I think you'll feel better. And it's not just your will. You really need powers of attorney. A power of attorney is where I say, Daryl, look, if I ever get where I can't take care of my affairs anymore, will you take care of my affairs for me? He doesn't own my assets, but I might need somebody to sign the checks or make decisions for me. That's a general power of attorney to take care of financial matters. There's also what's called a healthcare power of attorney, which is only for healthcare decisions. And eventually, y'all going to be in those situations where you got to decide to take somebody off life-sustaining mechanisms, that kind of stuff. That's what we're talking about. I mean, who's going to make those decisions?
Mike, as a parting thought, how would you recommend? Some of our good folks have attorneys, but there was a question earlier on from someone mentioned, how do I find a good attorney like you, Mike? Just words of guidance there.
He sounds like he's live me a softball.
Really, I'm not putting you on the mark, but how do you find it?
Well, most people that are landowners have probably had some deals with lawyers. Here's one thing I tell you: lawyers know who good lawyers are. It ain't the guys advertising on TV. It's not the guys that spend all day in the studio telling you. And I mean, those things just drive me up the wall. But you'd ask a doctor who a good doctor is. Ask a lawyer, in your neighborhood who they'd recommend to help you with these type issues.
That's good advice.
This is something I just grew up around, and I don't make my living doing hunting leases. It's really just business law for people in the outdoors. But I grew up in hunting clubs and running dogs, and I looked at all the crazy things we did. And what really got me interested in this a long time ago was I was reading articles about the staggering number of people that were getting shot, like 1975, 74. I don't know if you probably can't make that out, but 60 people got shot in Mississippi hunting in 1974. I mean, it was just getting out of hand. So they came in and started saying, maybe we ought to put something like Hunter Orange on, and that dramatically shifted the numbers down over time. But there's still, every year, you're going to read horrible stories about somebody being mistaken for game and shot. I checked this out yesterday. I'm always looking at it just to see what's going on. And the Mississippi Department of Wildlife, Fisheries, and Parks. Now, when I came up, we would sit next to trees. My dad would say, look, you rake the leaves out you get you next to a big tree and sit down. And we were running dogs. And so a lot of times we're trying to line areas and drive deer into it. We used to think, what kind of idiot would try to shoot a deer without dogs chasing it? I mean, that's the way we thought. Now everybody pretty much still hunts, and the deer can now move around and do their kind of thing. But we started out hunting on the ground, and then the tree stands started coming along, and that was the newest innovation. And now that helped because now you're shooting down. You don't have the same trajectory out through the forest where you might kill somebody that's driving the deer or something like that. But now the Wildlife, Fisheries, and Parks says over 90% of hunting accidents are now from falling out of tree stands. So now we're falling out of trees, and so here again in your hunting clubs, you require people to have safety harnesses. We try to make sure people are wearing Hunter Orange. You just got to make sure that's a priority. And besides all these mechanisms, the best way to solve these issues is just insist and prioritize it. We're going to hunt safe. And your hunting clubs, if people are shooting illegal deer, I hate that, because to me it tells me they either don't care or they're just guessing at what they're shooting at. And that's the recipe for getting a kid shot.
They're violating state law if they're doing that.
I just don't like that. I mean, you got to know, I get sick of seeing that mistaken for game. You can't make that mistake. It's kind of like, to me, it's like a drunk driver who said, well, I wasn't intended to have an accident, but you're going to bear the responsibility because you put yourself in that situation to kill somebody and you hold them responsible. And I don't think you can guess when you're pulling a trigger, so I hope all of y'all, when you go back and you deal with your tenants or your hunting clubs, that you'll be a voice for being safe and doing things the right way. And you're never going to know whether you saved a kid's life or something, but you know, you got to stand up and say, you're not going to go out there. You've been drinking all day. You ain't fixing to get in the woods. You know, you need hunting club presidents that'll enforce the rules, not just Mr. Popular, but you better have somebody that's got what it takes to get up somebody's face and say, we're not doing that, or even take somebody out of a club, because you'll have a better club when it's all said and done. If people know that you value their kids and safety, there's not a deer in the woods big enough to get somebody shot or get somebody hurt. So please prioritize safety. And I'll tell you, one of the things I've got is I've got a website, and I did that because Jamie Doris is talking, no, it was actually Kathy Jacobs years ago was talking about the internet. The more unique your situation is, like outdoor ventures like you're fixing to do, the internet is a great place, and all these social media things. So I set up a website called outdoorlawyer.com. So if you ever check out, if you want to check anything more, I've got videos, numerous articles and things I couldn't cover here today, but it's called www.outdoorlawyer.com, and you can find me that way if you need me. I better quit before I know I'm way past my time on it.
Mike, thank you so much. And when we sign off here, I'm gonna put your website in the chat box so you'll have that. And in the NRE site too, we have some information that's related to what Mike just said. I thought we had a really informative session today. Good comments here that I think the good people enjoyed it. Thank y'all for participating. And Mike kind of set this up. We do we have a session tomorrow on social media marketing. That's Jamie Doris. She's very talented. I think you'll enjoy her. Farm Bill program opportunities is Thursday with Kevin Nels with NRCS. And then I will talk to you on Friday for these types of businesses to write a business plan. So really enjoyed putting this information out for you. And to kind of say something else too, be sure to contact your local county extension office. They have good information too. They're available for you. We actually have some extension agents on today. So don't forget that as a real good source of information. Mike, while you're paging through the questions there, if you see one you want to jump in and just handle, I think we covered most of it. I did see someone talking about probate, with how do you avoid probate, but you're saying with a will, it's good to go through the process.
Well, you can avoid, a lot of people are trying to avoid probate, but it might be with joint ownership, payable on death provisions. Really, joint ownership is going to be your best way to avoid that. But that's something, again, you need a little help planning for if you can do it and maybe still miss the negative tax consequences. You just got to sit down with somebody and check it out a little bit.
Outdoorlawyer.com.
Yeah.
Okay. All right. This is coming. There's Mike's. I think that just went.
Oh,
did everybody get that? Outdoor lawyer. Okay. So thank y'all for participating today. Mike, we've been at it almost 2 hours. So our 2 hour 45 minutes. So that was a good talk.
All right.
And thank y'all for being here. And we look forward to having more contact with you. Contact me as well if I can help you. If you've got a legal issue, get in touch with Mike or me, and I'll line you in with Mike. And we just enjoy being service with you today. And Vern Allen is with us today as well. You haven't been able to see him, but he's part of the NRE program here at Mississippi State. Thank y'all for being here, and we'll see you hopefully tomorrow. Thank you, Mike. Appreciate your time. Bye, everyone.